The State Board of Health plans to meet again in the coming days to reconsider rules it adopted last week for the regulation of medical cannabis. The decision comes after the Attorney General advised the board it had overstepped its authority and amid more questions about why the board voted the way it did.
It's been quite a wild ride since the Board of Health met July 10th to adopt rules for the regulation of medical cannabis. The board's decision to approve two last-minute amendments banning the sale of smokable forms of marijuana and requiring a pharmacist be on staff at all dispensaries sparked outrage among supporters of State Question 788 and led to two lawsuits being filed against the board.
Filing this lawsuit on really behalf of
authorship of those amendments remains a mystery, and attorney Ronald Durbin, representing Green the Vote, believes it shows the board had violated the state's open meetings law.
We believe we have evidence that there were behind-the-scenes negotiations and discussions among certain members that we've named in this lawsuit to bring forth the amendments that essentially destroy the intent of 788.
The waters were further muddied when the Health Department's General Counsel, Julia Zell, who had advised against adopting the amendments, submitted her resignation, followed by the filing of criminal charges accusing her of falsifying threats against herself. Bud Scott with New Health Solutions Oklahoma, a medical cannabis trade group, says the bizarre turn of events leads him to believe there is more to the story.
Because the shift that occurred between the first draft of rules and the receipt to public comment, and then to see the draft that we had going into the meeting on July 10th, there's just not much you can account for here. There's a lot of communication going on behind the scenes, and a lot of folks that were communicating with the Board of Health members themselves.
And Scott believes he has a pretty good idea of who was behind those communications.
I'd say the state's medical association. I'd say some of the forces that have been opposing this since day one, and they worked with staff, and then I'd say they worked with the governor's office on this too, considering the governor signed off on those impermissible rules as well.
On Wednesday, State Attorney General Mike Hunter weighed in, sending a letter to Interim Health Commissioner Tom Bates saying he has come to the conclusion that the board acted outside of its statutory authority and advised members to convene a special meeting to amend the rules passed regarding medical marijuana. In addition to the two controversial amendments, Hunter also raised questions about rules restricting dispensaries to limited locations, requiring medical marijuana be grown, processed, and dispensed in enclosed structures, and limiting the amount of tetrahydrocannabinol, or THC, in flower, leaf, or concentrate. The State Board of Health has since said it will convene an emergency meeting to revise the rules, but Durbin says that's not good enough.
We have no faith that the Oklahoma Board of Health is going to take the appropriate action. We think what they'll do is just enough to sort of appease what they think they're required to do under the AG's opinion and go no further.
Durbin claims board members went into the July 10th meeting with the intention of crippling medical cannabis and subverting the will of voters who passed State Question 788.
We believe there's evidence to suggest that they weren't serving the interests of the people of the state of Oklahoma. They were serving a financial or an employment interest. And we think that the violations of the Open Meetings Act will show exactly what it is they were doing and why they were motivated to take the actions that they did.
Durbin is also calling for the resignation of any board member who may have bowed to any kind of outside influence.
If they put themselves in that position, they should get out now before this goes any further. We would much rather this be resolved now than a protracted fight in court, but we're in for the long haul if we need to be.
And he says Green the Vote, as yet, has no intention of dismissing its lawsuit.
Thank y'all so much. I don't know what they're going to do next week. If we're invited to the table and we can come up with resolutions to these things, then we're going to consider dismissing our lawsuit, but only under circumstances where change actually occurs. My clients are tired of getting stabbed in the back by the state.
Scott believes the series of events that have unfurled since the board's meeting demonstrates the need to take matters out of the health department's hands.
I think at this point, this has to become a freestanding agency to be able to issue these rules and really administer this program. I do think Tom Bates and his staff have done a heck of a job, but at this point, how can anyone have any faith that these rules are going to be done in a manner that is not intended to willfully disrupt the will of the people.
Meanwhile, a special bipartisan working group formed by House Speaker Charles McCall and Senate President Pro Tem Designate Greg Treat will begin meeting with stakeholders before making recommendations on a permanent regulatory framework for the implementation of State Question 788. The group's first meeting is scheduled for July 25th, just 1 day before the Health Department is required to have applications available for medical marijuana licenses.